Friends, how are you? Today I am going to discuss an important topic concerning your right under the Prevention of Corruption Act. My specific emphasis would be on Section 13, Subclause 1, Subclause E, which in nowadays has become the major problem for the public servant. Because even on the anonymous complaints, they usually implicate the innocent public servant by submitting that you are having the disproportionate assessed. So, what are the remedies? And sometimes it is seen that they usually connect our life partner or our son or daughter and internally imputed that through them you invested the money in the name of the Benami transactions. So, recently the Honorable Andhra Pradesh High Court discussed the said scenario in the efficient way. So, we have to know the basic structure, we have to know the basic rights and how they could be executed. So all these things are going to be explained by me in this video. So please note down whatever I am going to convey you. So if you are having the same problem or in future you may face the same problem, then this content may be useful for you to fight with these issues so that you could enforce your right in the efficient way. Friends, the judgment is passed by Honorable Andhra Pradesh High Court. The bench is Amravati bench and the concerned party name is V.V. Nageshwar Rao versus State of Andhra Pradesh. Judgment is pronounced on 24th of Jan 2023, in which the judgment of conviction and sentence imposed by the concerned trial court has been challenged. The primary contention is that although there are allegations against us, but still the prosecution is required to prove the offence under Section 13(1)(e) of the PC Act. No presumption could be drawn, and if they fail to do so, the adverse presumption could not be against us, because weak defense, no defense is not a ground to presume us to be guilty. The prosecution is duty bound to prove the case beyond reasonable doubt. And as far as Section 20 of the PC Act is concerned, the presumption in the said section would not be applicable in these cases. So first we have to know the facts, then the contention, so that we could draw the appropriate results from the court. In this case, the ACB police has received a credible information that the accused officer acquired the immovable property and immovable property which is called assessed, which is disproportionate to his known source of income. On this report, a crime number so-and-so has been registered against the concerned accused under Section 13(1)(e) and Section 13(2) of the PC Act. Subsequent to this, a surprise trap or check was conducted in the house of the accused officer and in any other places by the ACB police, and the check period was taken from a particular date, that is 30th of March 1977 to 6th of March 2010. It means from date of entry of accused in the office of government till the search is conducted in the residential house of the accused and his near relative. According to the prosecution, the investigation revealed that the accused officer acquired and was in possession of the assessed of worth rupees 1 crore approximately, and the same is shown in the annexure also. His income during the said period from all the known sources was too much low, and which is also shown in detail in particular annexure, and total expenditure incurred by the accused officer during the said period was very huge. It is also detailed in annexure number 3, and thus according to the prosecution, the likely saving of the accused officer from his known source of income is something 23 lakh rupees. So it is stated that the accused officer was in possession of disproportionate of the assessed in his name and in the name of his family, and particularly his wife and son was also targeted in the said report. Subsequent to this, it is averted that in spite of giving the opportunity to explain as to how he is in the possession of the said assessed, he failed to do so. So this is a very important point. Usually in cases of Section 13(1)(e), we usually take it very much lightly, but give your explanation by consulting with the appropriate CA and the lawyer, so that you could produce an efficient defense before the concerned authority while processing your case. So this is a major fault on our part while dealing with such type of cases. According to the prosecution, most of the immovable property are acquired by the accused either in the name of his wife or son, or they are termed as Benami transaction, and apart from that, the concerned accused person is liable to be prosecuted under Section 13(1)(e) with Section 13(2) of the PC Act as mentioned in the charge sheet. After completion of the investigation, the charge sheet has been filed, the accused has been examined, and ultimately charges has been framed against him as per the protocol of Section 240 of CRPC. the same was read over to him and he claimed to be tried. Subsequent to this, the prosecution put up his case, they examined the witnesses and also submitted document and also marked them as per law. Subsequent to this, the statement of the accused has been recorded as per section 313 of CRPC, and ultimately he also filed the written statement and also submitted the defense evidence to sustain his innocence. After conclusion of the trial and considering the evidence, the concerned trial court had convicted the accused with sentence and with fine as well. Subsequent to this, he has filed the appeal before the Honorable High Court. His primary contention is that the concerned trial court had failed to consider the entire evidence on the record in the efficient way and judgment is impugned, it is liable to be set aside and quashed. The primary contention of the appellant is that 20 immovable property and 8 movable property were shown by the prosecution in the list. And among the said 20 immovable property, only 2 properties belongs to the concerned accused. And the remaining property are in the name of wife, but he has submitted that the wife is having the source of income, he is also having the sufficient sources and business, and also she is an income tax assessee, and that's why she is having the sufficient earning, and all the property that is inter alia submitted to be Benami is purchased by her as per the available sources, and that's why the concerned defense point and the defense witness and defense document has not been considered by the concerned trial court in the efficient way. That is a prime contention by the concerned advocate. The second prime contention is that the accused is totally innocent and it is a duty of the prosecution to sustain that the concerned accused is inter alia involved in the activity of Benami transaction. Apart from that, he had submitted the witnesses the document to show that the alleged property does not belong to the concerned accused, rather than it belongs to his wife and son, and they have purchased the same through their own available economic sources. So when the sources are available, it is shown in the concerned income tax assessment or return. In that scenario, the accused could not be prosecuted and he could not be held liable for the alleged Benami transaction, which is not done by him as alleged by the concerned prosecution. Primary contention of the accused appellant is that the charge sheet has been filed after retirement of the accused because the concerned authority awaited till his retirement so that the requirement to obtain sanction could be avoided. But the primary key is that the sanction is required and without which the accused could not be prosecuted and convicted. And that's why, looking to the facts and circumstances, he claimed the impugned judgment is liable to be quashed and set aside. The same is opposed by the concerned public prosecutor. His primary contention is that the evidence is on the record which is totally sufficient to conclude that the accused had acquired the assets in the name of his wife and son, and that's why he is involved in the Benami transaction, and that's why he is guilty as per section 13 subclause 1 subclause E of the Prevention of Corruption Act, and he is rightly convicted by the concerned trial court. But the fundamental fact before the court is that there are property, it is uncontroverted fact, it is in the name of the wife and son of the public servant, it is uncontroverted fact. But if they are able to show the real source, the real income, the real assessment, even though by avoiding this fact, the concerned public servant could be prosecuted under section 13(1)(e) of the PC Act by merely on the ground that the concerned prosecution is submitting that he is involved in the Benami transaction and he has acquired the concerned assets in the name of his wife and the concerned son. Friends, while addressing the court on the same issue, the concerned counsel for the accused appellant had drawn the kind attention of the court towards the important issue as laid down by the another bench of the Honorable Andhra Pradesh High Court in M. Serumullu versus State of Andhra Pradesh. In this case, the primary key is that whether the concerned public servant is involved in the Benami transaction or not, the burden is on the prosecution. If prosecution does not specify the real transaction, in that scenario, the concerned public servant could not be prosecuted on the mere surmises and the conjecture. So this is the basic intent of law. The prosecution is required to prove the case beyond reasonable doubt, and if it is failed to do so, in that scenario, it could not connect the accused with the crime. It is further observed by the court that it is well settled law that if the wife of a public servant is also having the independent source of income, she is income tax assessee and she occupies some property, either movable or movable, in the name of her, simply on the ground that she is living with the public servant could not be a ground to presume that the property purchased by the concerned public servant in the name of his wife or son in the name and term of Benami transaction. The husband is not the implied agent of the wife to deal with her property. The wife may be the lawful owner as per her own discretion and the conscience. So the primary key is that as per law, the husband and wife are independent identities, and if something is purchased by the wife in her own name and she is having the sufficient means, she is having the financial capacity, in that scenario, her conduct, her properties could not be connected with the conduct and properties of the concerned public servant, and it could not be assumed that the public servant has done the Benami transactions. Hence, the Honorable Court also relied on judgment of Allahabad High Court, in which it is specified that by the virtue of marriage, it doesn't mean that a husband has no authority to contract on the behalf of his wife. But the primary key is that the wife has a right to enter into a contract as per her own will and conscious and in the independent way. Thus, looking to the fact and circumstances, the court observed that the position of law is quite clear, that if the wife owes the property in the separate way, in that scenario, it shall be presumed that she act as per her own will and authority. The husband in that scenario could not be presumed to be an implied agent to deal with her property. So, the legal position is that the wife could own the property, could occupy the same in the capacity of owner without any intervention from the husband. So, the said task and conduct is totally independent. So, the prosecution have to prove with strong legal evidence that the husband inter alia indulged in the activity of Benami transaction and he inter alia purchased the property in the name of wife so that he could be free from the clinches of law, but in fact he has done the crime of serious nature and affected the economic condition of the country in term of section 13(1)(e) of Prevention of Corruption Act. So the primary key is that the proof of Benami transaction is required to be proved by the party who is alleging. By mere surmises and conjecture, the concerned accused could not be convicted under the law in force. Honorable Andhra Pradesh High Court had relied on number of judgment. One of the cases Jaya Dalal versus BB. In this case, the court held that it is well settled that the burden of proving that a particular sale is Benami is on the prosecution. By mere presumption, by mere surmises, by mere conjecture, the accused could not be prosecuted, even convicted. And apart from that, in number of cases, the position has been made clear, even by the Honorable Supreme Court. First thing is that the source from which the purchase money had come is quite important in these factors as a determining force. And apart from that, the Honorable Supreme Court in number of cases has specified that we could not make a straitjacket formula, but the things are that on which basis we could conclude whether a transaction is Benami or not under the following categories: the source from which the purchase money had come, the nature and possession of the property, the motive, the relationship between the parties, and the conduct of the parties. Again, in the case of Bhim Singh versus Khan Singh, it is specified that the Benami transactions, the burden to show that a transfer is Benami is on the person who make the submission. It means the agency. By mere presumption, by mere assumption, we could not presume the accused to be a guilt. Apart from that, in the case of S.K. Devi, it is specified by the Honorable Supreme Court that whether a property standing in the name of the wife shall be accepted as Benami purchased by the husband in the name of his wife or not, it depends upon the fact and circumstances. And apart from that, it is a duty of the concerned prosecution to prove that the alleged transaction is Benami transaction, and ultimately it is a property of the husband and he transacted the same in the name of his wife to get evade from the liability. So in that scenario, he could be held liable for disproportion of the assets, but in the routine manner, the said prosecutions could not be approved. In another judgment, the Honorable Apex Court in Gapadi Bhai versus State of Madhya Pradesh specified that it is the concerned prosecution who has to specify that the transaction is Benami, without which the accused could not be prosecuted under law. And finally, the court concluded that the legal position is quite clear that in order to prove that the property are standing in the hypothetical manner and the actual owner is the husband and the said transaction being a Benami transaction, the burden is on the prosecution to prove and establish the actual sale consideration was paid by the concerned accused officer. If such a scenario is totally absent, in that condition, by the fiction of presumption, by the fiction of conjecture and surmises, the accused could not be prosecuted because the said scenario does not come with the preview of legal evidence, and in that connection, the concerned accused person could not be prosecuted in the routine manner. So, in the present case at hand, the court specified that whatever evidence are brought on the record regarding the purchase of the concerned properties are in the name of the concerned wife and son, and they have specified that they are having the financial source and out of their own sources they have purchased the concerned property. So in that scenario, the concerned accused person could not be tagged as he has done the Benami transaction. So ultimately, looking to the facts and circumstances, the court observed that if such scenarios on the record where wife is earning, son is earning, and they are having the sufficient source of income, and the accused person also specify them, and inter alia by the way of sufficient evidence these facts are proved, in that scenario it could not be presumed that the accused person is guilty for the Benami transaction and he is guilty for disproportion of the assessed. So looking to the fact and circumstances, the court found that the concerned trial court has committed the error, and apart from that, the concerned trial court has not given the specific reason the defense witnesses should be weighed on the same way in which the prosecution evidence are going to be weighed by the concerned court. So this is an important legal parameter, and if this parameter is not considered by the court, this citation would be quite helpful to you. So don't be disappointed, just secure your rights and definitely we will win. If this topic strengthened you, conceptually enlightened you, then share and like this video and subscribe my channel so that you could get these legal updates in the efficient way. Friends, don't be disappointed. Just fight for your rights and definitely we will win. See you in the next video. Till then, Jai Hind, Jai Bharat.